You mentioned how the ballot initiative kind of dictated the types of rules and kind of steered the direction of the MRA and what types of rules were included and kind of, compared to the MMFLA, where you were hands were a little more tied by that legislatively passed law. One thing I did note too, that there's different eligibility requirements that are, I know the ballot initiative had in there, that are reasonably related to kind of, being in business in the industry, as opposed to that laundry list of disqualifying factors for the MMFLA. So things that I saw in there that were positive, fewer barriers to entry were, the criminal conviction had to be solely related to distributing to a minor. Even for employees, there was, that same language that allows for more people to work within the adult use industry. And then also, acknowledging that was an automatic disqualifier, you're kind of looking at, more of a permissive, have the option of denying them if there's a pattern or practice that kind of dictates that to the agency that the operation won't be run with honesty and integrity. So I thought that was that opened it up a little bit more to interpretation in a good way. I think is just kind of another, along with the tiered licensing fees, opening up the floodgates a little bit more to allow more people to participate, I think is a very good thing.
We want to create an environment where it's more inclusive for all types of businesses, for the different sizes of businesses, and obviously there was a clear intent in the ballot initiative not to exclude people that had certain types of previous convictions related to marijuana specifically. So we took that to heart when we looked at what we were going to put in the rules when it came to eligibility requirements, and tried to really only include things that we thought directly might have a bearing on someone's ability to operate in a compliant manner and therefore potentially impact public health, safety, and welfare. And if we couldn't make that argument conclusively, then we didn't include it as a requirement.
Let me talk about that a little bit further, because the elimination of minimum capitalization requirements definitely eliminates a barrier to entry. Although we all know that it's still, the agency is not going to take applications from anybody else except for those that are licensed with a medical license, except for microbusiness and for Class A. So it still is there a little bit. But with respect to the designated consumption license, which is another special license that's been introduced, could you describe, first of all, the importance of this type of license, and also whether it's going to be necessary for there to be any type of minimum capitalization requirement to that? Like, I guess what I'm saying is, do you require, what are the eligibility for getting one of those licenses? Does it require a medical license first?
It does not require a medical license first, no specific capitalization requirements. So the general conditions for eligibility for licensure overall would apply in the same way for a designated consumption establishment. And when we looked at the types of special licenses that could be created, and I will say that as a regulator, it's not often that you get delegated some authority to be a little more creative and look at what the industry may need to be successful. So that was a nice twist in the ballot initiative, that we had the opportunity to do that. I hear a lot, having been a regulator for 15 years now, about things that the industry wants to see created and participants think would be beneficial that need to be done statutorily. And unfortunately, that's not always the easiest thing to achieve. If you see an opportunity for business growth in the state, a market that needs to be served in a certain way,